Ms. King and Mr. Finley on behalf of the Canadian Public Health Association.
Thank you, Chief Justice. The Canadian Public Health Association has been at the forefront of the advancement of public health research, policy, and practice in Canada for over 100 years. Climate change is properly understood as a public health issue. There is scientific consensus that it is the biggest global public health threat of the 21st century. In our brief submission today, Mr. Finley and I will aim to demonstrate how the public health evidence and jurisprudence assists the court in this reference. The Canadian Public Health Association submits that the federal government has a necessary role to address the national threat of climate change. There is no controversy that there are currently and there will be serious national public health impacts of climate change, and these impacts do not respect political borders. There also does not appear to be any dispute that a federal role, distinct from the province's role, is necessary to address this threat. As with other national public health problems, public health recognizes that effective solutions to climate change require collaboration and cooperation among all levels of government. The IPCC has concluded with a high degree of scientific certainty that mitigating the severity of climate change impacts will require some form of budgeting of GHG emissions on a national and international scale and multi-level governance to overcome regional constraints. Canada's First Ministers recognized in the 2016 Vancouver Declaration that all governments should be mobilized to face the challenge of reduction of global emissions. Most significantly, Ontario, in its November 2018 Made in Ontario Environment Plan, which you can find at tab 4 of Ontario's record, and page 22, I'm going to refer to page 22 of the record. Ontario calls on the federal government to proactively address the impacts of air pollution from outside Ontario and ensure continued cooperation and commitment to improve air quality. Ontario's own plan recognizes the necessity of federal involvement to solve transboundary air problems. Ontario needs to call on the federal government to ensure neighbours are addressing air pollution because Ontario cannot do it by themselves. This evidence is consistent with there being a concurrent jurisdiction over GHG emissions, like there is with other matters of public health. Public health, like the environment, is not assigned to either the federal or provincial legislative authority in the Constitution. The Supreme Court of Canada has repeatedly recognized that it is subject to concurrent jurisdiction, and I specifically refer the court to the Schneider decision, which you can find at tab 11 of our Book of Authorities. Justice Etsy held that health can be addressed by valid federal or provincial legislation, depending in the circumstances of each case on the nature or scope of the health problem in question. Chief Justice Laskin, at paragraph 1 of that case, cautioned that a finding of provincial authority over a health matter must not be taken as excluding federal authority over public health. And in that case, Justice Dixon divided the legislative domain over the health subject of narcotics according to the nature of the measure taken. Illegal trade in narcotics coming within the jurisdiction of Parliament, and the treatment of addicts under provincial jurisdiction. So how do we divide the legislative domain over GHG emissions? This is one of the questions that this court has been grappling with over the past few days. And in our submission, this public health evidence and the case law provides guidance on how to approach this question. In particular, I refer the court to the Supreme Court of Canada's decision in the Insight Safe Injection Site case, which you can find at tab 6 of our Book of Authorities. In considering the division of powers arguments, Chief Justice McLaughlin cautioned against finding new areas of exclusive authority, particularly over broad topics like public health. At paragraph 60, Chief Justice McLaughlin notes that interjurisdictional immunity has never been applied to broad and amorphous areas of jurisdiction. She raised 3 concerns, which assist here, at paragraph 62 to 64. 3 concerns with regards to interjurisdictional immunity. First, it is in tension with the double aspect doctrine. Second, it is in tension with the spirit of cooperative federalism. Courts should avoid blocking the application of measures which are taken to be enacted in the furtherance of the public interest. Where possible, courts should allow both levels of government to jointly regulate areas. Third, the result of limiting federal jurisdiction where there is overlapping jurisdiction may create no-go zones where neither level of government regulates. We have the same concern here. Limiting Parliament's authority over climate change has the risk of creating legislative vacuums. Can it be that the federal government has a necessary role to solve this serious, pervasive threat, but they do not have the power to do it, where the provinces cannot or may not be willing to exercise their role? As Chief Justice McLaughlin puts it at paragraph 69 of that decision, this is inimical to the very concept of the division of powers. Chief Justice McLaughlin found that in areas of overlapping jurisdiction, like we have here, the modern trend is to strike a balance between federal and provincial governments through the application of the pith and substance analysis. That's at paragraph 65 of the decision, and a restrained application of federal paramountcy. Chief Justice McLaughlin assists us in understanding why the order of approaching the test is relevant and why it's important. Because the balance between federal and provincial jurisdiction is struck in part through the first step, the characterization of the matter, which in Chatterjee, the Supreme Court held is the essence of what the law does and how it does it. This step must be addressed first. By reversing the order and starting with the second step, classification, the Attorney General of Ontario strips the context from the discussion. The context of the legislation matters. That is, not only what it does, but how it does it. Responding to Associate Chief Justice Hoy's comment from yesterday, in our submission, the characterization can be narrowed by addressing how the Act achieves a reduction. For example, it could be characterized as a minimum national carbon price to reduce national greenhouse gas emissions.
Sorry, would you give that to me again?
Yes. For a minimum national carbon price to reduce national greenhouse gas emissions. And it's only at this stage that we turn to the second step of the test, classification of the essential character of the law by reference to the federal heads of power. In CPHA's submission, the essential character of the Act comes within the jurisdiction of Parliament under the national concern branch of the POG power or the criminal law power. In our brief submissions, I do not have time to make our submissions on the POG power. I will just refer the court to our factum at paragraph 17 to 26. Mr. Finley will make brief submissions on the criminal law power.
Brief is about 2 minutes, Mr. Finley.
Fair enough. I'm going to piggyback, luckily, from my colleague from the Canadian Environmental Law Association, refer this court to two decisions, the RJR McDonald decision of the Supreme Court and the decision of the unanimous Federal Court of Appeal in Syncrude. And I'm focusing on the health aspects of those decisions. And what I submit RJR McDonald shows us is that the criminal law power is flexible in the face of a complex public health problem that's nationally pervasive. And in that case, the problem was the ill effects of smoking. And having reviewed the background of that act and the problems underlying it, the court held it is apparent from these comments that the social problems created by tobacco consumption are complex and that innovative legislative solutions are required to address them effectively. And that's at paragraph 36 of that decision, which is at tab 9 of our Book of Authorities. The court found that it was possible to adopt that flexible approach through the criminal law power. We say the same is true with GHG emissions, and we see that embodied in the decision of the Federal Court of Appeal in Syncrude. In RJR, the court found it was possible to adopt a circuitous path to achieve policy goals through criminal law. And in Syncrude, who was the appellant, argued that that wasn't a criminal law. It was a regulation that required minimum amounts of renewable fuels and diesel. And so it was an economic regulation, not a criminal law. And the Federal Court of Appeal disagreed, finding that GHGs are harmful to both health and the environment, and as such constitute an evil that justifies the exercise of the criminal law power, and that's at paragraph 62. And there are two important points that follow that at paragraph 68 and 69. First, the valid use of the criminal law power was not negated simply because Parliament hoped to create market demand because it had a mini cap-and-trade system in effect in that regulation. And secondly, it was not negated simply because Parliament foresaw a behavioral response. And so the fact that managing economic effects playing a role, even a large role in a piece of legislation, does not mean that the law is a colorable attempt to pursue an unconstitutional objective underneath the criminal law. Otherwise, I commend you to the paragraphs 33 and 42 of our factum, where we set out this argument in detail, including what I hope is a helpful outline of some of the similarities between CPHA, the Canadian Environmental Protection Act, which my colleague already took you through, and comparing it as against the act at issue here. I'll just leave you with a quote from Syncrude. It would be extremely easy for Parliament to use the criminal law to protect the environment if Parliament had no concern for the economy. It could simply ban the consumption of fossil fuels. The challenge, and this is the important part, the challenge lies in protecting the environment while avoiding negative economic side effects, in some cases, crafting the regime so as to mitigate the economic side effects, maybe the majority of the work. We say that is what is happening here with the federal act in question, and that public health protection is a part of that effort. Thank you for your time.